师、尊敬的张文正律师，你们好，我是海南国际仲裁院的这个林英波，非常高兴有机会今天参加这个线上的这个讲座，也欢迎我们业界的各位同仁一起参加这次线上的这个培训活动。我们这个海南国际仲裁院是海南省政府在全省依法组建的一个民商事仲裁机构，它的性质呢是社会公益性法律机构，实行这个理事会主导下的法人治理结构，作为非营利法人呢独立运作。那么在上个月，也就是8月25号海南国际仲裁院的第一届理事会第一次会议呢，在海口已经顺利召开。那么理事会呢，通过了这个我们仲裁机构的一些重要的规章制度和争议解决规则，也产生了这个院长和副院长的人选。各位理事呢，对海南仲裁工作的发展呢，也达成了共识。那么我们也相信，在不久的将来，海南国际仲裁院将会以一个崭新的面貌出现在大家面前。那么海南省呢，是我们国家比较年轻的一个省份，也是一个最大的经济特区。那么海南也是中国唯一的一个热带气候的一个省份。1988年建省以来经过30多年发展，现在已经成为中国改革开放的一个重要的窗口。那么海南的这个地理和人文的情况呢，各位可能也有所了解。行政区划呢，包括海南岛、中沙、南沙、西沙群岛以及其他一些岛礁，陆地面积有3.54万平方公里，海域面积呢有200多万平方公里，是中国面积最大的省份。如果从这个区划上来讲，那么另外呢，海南也是中国最大的自由贸易港。2018年以来这个中国政府决定支持海南全岛建设自由贸易试验区，支持海南建设中国特色的自由贸易港。那么今年的6月1号呢，海南自由贸易港建设总体方案正式发布。这个方案呢，也是彰显了中国扩大对外开放、积极推动全球经济全球化这种决心的这种重大的举措，也就是把海南再一次推到了改革开放的最前沿，也就是海南也迎来了重大的历史发展的机遇。那么今天我们这次活动的主题呢，是关于运输和航运这方面的一个主题。那么纵观国内外，世界著名的自由贸易港都是以建设国际航运中心作为重要的载体和依托的。那么高质量的航运中心建设呢，将会更好的与自贸港建设呢实现优势叠加和功能协同，助推全面深化改革开放。那海南建设国际航运中心有区位方面的优势，也有政策方面的优势，更有资源方面的优势。那么2018年9月23号的时候，海南国际仲裁院呢设立了海事仲裁中心，也就是在我们现在这个杨浦港设立了海事仲裁中心。这也意味着海南国际仲裁院成为自贸港建设和发展，在为海南海事、海商仲裁业务的发展提前做好了相应的准备，也奠定了基础。那么我们今天线上这个讲座的这个主题关于海南免税贸易、免税运输和贸易枢纽离不开航运，这个主题特别好，也是非常适应海南自贸港建设，尤其是涉及到海商、海事仲裁方面的一个重要的内容。所以我们今天线上讲座的这个主题作为海事仲裁专业很高的一个内容那么我们海南也好，我们 国内的其他各地一些业界同仁也好，对海事仲裁的接触啊还不够多，所以我们通过这次讲座呀，可以让不同的仲裁话题能在海南国际仲裁这个平台上，让大家能有一个交流的机会，也让更多人呢能够通过海南仲裁的平台啊进行专业性的探讨。那么在未来啊，我们也通过海南国际仲裁院为大家提供一系列不同主题的讲座和研讨会，希望我们在线的各位观众呢继续给予关注，有更多的参与。今天我们的主讲人大家事先也都看到了，这个许顺光律师和张文正律师啊，都是比较知名的资深的国际航运法专家，也是国内外知名仲裁机构的这个多家仲裁机构的仲裁员，他们都有着丰富的海事仲裁案件的审理经验。这两位专家呢，也是我们海南国际仲裁院新聘任的外籍仲裁员。那么许顺光教授呢，也是第4代的海南华侨，长期以来都十分关注海南的发展，对海南有很深的情结，对海南仲裁的发展也提供了非常多的宝贵的意见。那么我想也借此机会啊，向许顺光教授表示衷心的感谢，谢谢许教授。那么我们今晚的讲座呢，将有2位老师呢分别进行演讲，其中许顺光老师是用中英双语讲座，张文正律师呢是全英文讲座。为了让各位听众理解，我们也提前对张文正律师的这个 PPT 进行了翻译。如果时间允许的话，也希望大家能够在线上呢提出一些问题，和各位专家呢进行探讨。希望大家能够把握好这次难得的交流和探讨的一个机会。那么最后呢，我也代表海南国际仲裁院，预祝我们今晚的这次线上的讲座活动取得圆满成功，也谢谢大家的参与和支持，谢谢各位。
谢谢。
尊敬的林宁波秘书长，各位朋友，各位来宾，大家好，我是第4代海南华裔，我去了海南岛不是1、2次，我已经到了海南岛7、8次了，很喜欢这个省。首先呢，我要感谢我和张律师，我们要感谢海南国际仲裁院给我们这个机会，让大家分析海事仲裁的原则，海事仲裁的系统。第一呢是 Maritime arbitration，why not 海南，就是海事仲裁为什么不在海南呢？第一呢，首先呢，我要解释什么是海商法，什么是海事法，什么是航运法。秘书长刚才也解释这3个字，海事海商。那我简单的跟大家分析，因为我们2位当海事律师也超过30年，是海商海事，英文有3个字。第一呢是 Maritime， 第2呢是 shipping， 海商航运，第3呢是 maritime shipping 这两个字，还有另外一个字，英文是 admiralty，maritime admiralty shipping 是有时候是同一个意思，有时候可以分两个意思。那海 maritime law 最好是用那个 maritime law。maritime law 呢有分两个部分。第一个部分呢，在英伦呢，我们有 wet， 就是很湿的海事法部门 wet arbitration。wet arbitration 包括碰撞案件，包括救赎 salvage 就是救赎。第二呢，拖航就是 towage。第三呢是引航，这就是 wet 的仲裁部分。第二部分呢就是干，真正是这个是干。那个干的意思呢，包括航运 carriage of goods by sea 就是航运。第二呢，包括提单合同。第三呢，租船合约，最后呢就是海上保险。所以很简单的给大家分析什么是海事海商法，因为海事跟海商法在英伦也好，新加坡也好，有一些很特别的概念，很特别的法律，跟别的普通法系统有一点不一样。就是为什么一艘船呢？我们用这个英语 ，She is a beautiful ship. She is a beautiful ship. 第二 ，next slide. 第二，那今天的海南呢，我不需要推荐你们知道，海南是亚洲的夏威夷，整个海南岛也是一个免税国贸中心，海南的港口也是很有名的港口，还有博鳌高位这个博鳌开位也是在这个岛，还有最重要的是，整个亚洲只有海南岛有一个医院等。第四点呢 ，Asia's only hospital park is located on this island。刚才你们就已经写了，英文是我的第一语言，中文是我的第二语言，法文是我第三语言，我已经是第四代海南唯一了。那张律师呢？第一语言是英文，第二语言是马来文，第三。仲裁地点呢？仲裁地点呢？海事还有商业仲裁中心，很多年都是在世界3个地方：伦敦、纽约。现在我们不要考虑美国纽约了，只要伦敦、中国跟巴黎就好。那海南呢？是一个刚才理事长已经提起了一个免税的港口、免税的国贸中心，所以将来呢，用这英文这个是 inevitable， 就是很可能性当一个很重要的海事纠纷地点。那海南的仲裁院有一个非常好的市场，因为海南华裔大部分都是在3个国家，新马泰，这是你们已经有了一个品牌了，你就是新马泰海南人。所以今晚呢，我要讲几句海南话，感謝路南。Next one, please. 现在呢， 委托我的助理，我在海口也有一个很优秀的海南助理，他是华政法学毕业生，目前是在海南大学的法学研究生，他的名字是唐佳英。唐佳英，帮我读仲裁地点。
大家晚上好，我是唐佳英。在海事和商事仲裁方面，新加坡目前是被列为继伦敦、纽约和巴黎之后的全球主要仲裁地之一。海南作为自由贸易港和免税中心，必将成为将来海商事案件的重要纠纷解决地。海南确实得到来自新加坡、马来西亚以及泰国的很多华人的支持，这也将是海南国际仲裁业发展的基础。
好，今晚的内容呢，包括第一，跟大家分析管辖权；第二呢，很重要呢，你们要很重要跟大家分析就是仲裁协议的独立性，这3个字，独立性。还有呢，仲裁机构的建立。第四呢，当仲裁员需要什么资格呢？还有仲裁庭的临时裁决和程序性的权利，需要仲裁的司法协助吗？在英美、在英国、英伦、在新加坡，这是很少得到司法协助的。还有呢，有些仲裁有一部分是仲裁，另外一个小部分就是调解。法院上诉权，法院上诉权的机会是很少。最后呢，我跟大家分析的是仲裁裁决。另外 ，preliminary issue 主题好几个宪法。第一呢，我跟大家分析的是英国的是仲裁宪法，1996年是仲裁法，但国家的国际商业仲裁主要参加了就是那个 arbitral 联合国国际贸易法委员会的示范法。那我就从现在开始，我就用这2个英文字 model law。那新加坡呢有2个仲裁宪法，第2个呢就是国际仲裁法， right？ 很清楚的，国际这个 model law 呢，除了第8章以外，它全部是都接受这个 model law。那中国呢是有2种宪法，一种是你们的 civil procedure law 民法，还有你们的仲裁法，就是 arbitration law 很详细的仲裁法。你们还没有完全接受这个 model law， 但是会受到示范法的影响，已经被示范法的影响了。Next one， 好，主要议题 Maritime State 呢，是那些海洋国家。海洋国家呢，应当有海事仲裁员专家协会，可以制定本国的海事仲裁程序规则。好像伦敦有 LMAA， 张律师和我们都是 LMAA， 就是伦敦海事仲裁协会的仲裁员，也是他们的会员。第2呢，在新加坡呢有 SCMA， 就是新加坡海事仲裁员。中国呢，在北京有中国海事仲裁委员会，上海也有 上海国际海事仲裁庭，那以后跟将来最重要的是你们的海事仲裁院在你们的海南国际仲裁院。我没有放 USA， 不要浪费时间，没有放美国的宪法。Jurisdiction 就是分析管辖权的问题。Jurisdiction， 英国呢，那个 seat of arbitration 需要在英伦或者是威尔士，在新加坡呢没有这个必要。那个国际仲裁宪法，除非一个当事人不住在新加坡，没有营业在新加坡，就可以申请国际仲裁庭审他们的案子。仲裁不施行地域管辖，仲裁委员不按行政区的设位，这就是中国法。中国法有一点跟英伦不一样。我觉得 no restriction on the location of the seat under PRC arbitration law， 这样是最好，还比新加坡和英伦开放 flexible， 不需要有一个 seat arbitration 在国内，在国内也可以，在国外也可以。好，另外，OK， 现在呢就是管辖权。OK， 英伦还有当事人最重要的是呢，只有管辖权的法院才能采取临时措施。这个是在中国，在英伦呢，那个仲裁庭可以命令他自己的管辖权。这是在英伦法律可以规定他们有没有管辖权，自然的管辖权。法院裁定有关实体管辖权的问题，或者可以审查仲裁院关于其实体管辖权的决定。这是在新加坡、英伦都有这个一样的管辖权。另外 competent 是一个法规，这个原则来的。competent， 在新加坡是国际仲裁宪法。那个当事人可以申请法院这个权利，法院可以命令有关管辖权的法律问题。那新加坡已经接受了 model law， 也给仲裁庭这个权利。在中国呢，有一点不一样，这个原则，法律原则 competent is not fully recognized， 不是完全接受，对吗？这样子呢，当事人可以聘请法院或者是仲裁庭，最好是法院去命令仲裁协议的效果。任何事情都有这个权利，当事人可以申请法院，这是在 中国那看第二呢 ，arbitration commission 就是一个仲裁庭或者是法院对这个权利命令管辖权的问题啊，我问这个我的研究生跟我研究目前的中国法现在是怎样呢？他给我这个回答：仲裁庭直辖管裁权严的，在中国呢，你们的仲裁法呢20条款已经有这个字 ，if a party challenges the validity of the arbitration agreement, he may request the arbitration commission to make a decision. OK， 假如是任何当事人 challenge 就是可以 challenge 一定，那法院可以命令管辖权的问题。OK， 嘉英 ，you can read。
在新加坡和中国就管辖权问题都做出了相关的规定。新加坡有个国际上市仲裁法的第10条中规定了仲裁庭可以裁定其在仲裁任何阶段不具有管辖权。第10条第3款规定当事人也可以申请法院裁定管辖权问题。在中国呢，管辖权自治原则尚未得到完全认可。在管辖权问题方面，仲裁委员会和人民法院可以进行裁定。当事人如果对仲裁协议的效力有异议的话，也可以向法院或仲裁委员会提出。
所以在中国，法院可以裁定这个管辖权的问题。Next one， 另外很重要，就是仲裁协议独立性。仲裁协议独立性，在英国呢，除非是两个当事人不同意，那管辖条款是独立的。假如是那个合同，任何合同，租船合同也好，买卖合同也好，假如是合同没有效果，但是那个管辖条款是独立的，不会影响到管辖条款的独立性，这是非常重要的。这个是在英伦。另外，在新加坡呢，新加坡接受那个联合国的 Model Law 第16条款也是一样。你看，第一 arbitration clause 是仲裁条款。假如是仲裁条款在一个商业合同也好，那个条款呢，就是一个仲裁合同，是一个独立的仲裁合同。合同呢，可以无效的合同，但是呢，我用一个拉丁整理，就是 ipso juri invalidity of the arbitration clause， 就是不会影响到那个仲裁条款的独立性。ipso juri， 我们在英伦的时候学法律的人，有时候还要学一点点拉丁文字。那在中国呢，也是很明确、很清楚的。 the effect of an arbitration 一个合同的影响呢，有效果还是没有效果呢？不会影响到仲裁条款的独立性。另外，好，这是仲裁协议的独立性。刚才我提起的是一模一样，但是现在呢，我就用英文读给你们听，就是16E条款，联合国的 Model Law。An arbitration clause which forms part of a contract shall be treated as an agreement independent of other terms of the contract. A decision by the arbitral tribunal 就是可以一个仲裁员或者一个仲裁委员会，不会影响到仲裁条款的独立性。Even if the contract is null and void， 就是没有效果。在中国呢，是你们的仲裁法律是有条款。The effect of an agreement for arbitration shall stand independently， 就是有独立性，不会让重要的合同影响。条款是独立性的，合同可以取消，但是仲裁条款还是存在，因为仲裁条款是有独立性的，很重要。仲裁协议的独立性，在英伦、新加坡一模一样。
在新加坡和中国，仲裁条款都具有独立性。在新加坡，联合国国际商事仲裁示范法的第16条规定了仲裁条款作为合同的一部分，应当视为独立于合同其他条款的协议。仲裁庭关于合同无效的决定不涉及仲裁条款的无效。在中国，仲裁法的第19条规定了仲裁协议独立于合同内容而存在，合同的变更、解除、终止或无效不影响仲裁协议的效力。
仲裁庭的组成，在英国呢，party 当事人他们有一个权利选有多少个仲裁员，假如是3个，需要一个当主席吗？或者是 umpire 就是裁判员。那当事人也可以同意选择仲裁员的程序。还有呢，假如当事人不能同意呢，这样子呢，就是要让给那个仲裁庭还是仲裁协会做决定。这就是仲裁庭的组成。另外，这也是一样的，仲裁庭的组成，在新加坡，当事人有一个选择，这是按照联合国的 Model Law 来程序。还有他们选择不可以有一个仲裁员呢，还是3个？3个呢也可以。有的是有3个呢，需要一个当 umpire 吗？裁判员、主席、裁判员，还有 组成的程序。中国呢，我已经理解了是一样。假如是3个人呢，肯定1个人呢就是裁判人。这是中国的仲裁法。那第3呢 ，Chairman of the Arbitration Commission。Arbitration Commission 呢，就是仲裁庭的主席。任何时间可以选仲裁员，假如是当事人不能同意。OK，next one。
在新加坡示范法规定了当事人可以自由约定仲裁员的人数。国际仲裁法的第9条规定了，如果当事人未约定仲裁员的人数，则适用独任仲裁的相关规定。在示范法和仲裁法中都有规定仲裁员的委任程序。在中国的仲裁法的第30条至32条也有类似的规定。第30条说到了，仲裁庭可以由3名仲裁员或1名仲裁员组成。如果是由3名仲裁员组成的话，可以设1名首席仲裁员。第31条规定了当事人各自选定或各自委托指定1名仲裁员，首席仲裁员由当事人共同选定或者共同委托主任指定。第32条规定，如果当事人未达成合议，则仲裁委员会主任将指定仲裁员。
好，那仲裁员的资格呢？在英伦海事仲裁啊，一般呢50%是商业人是 commercial arbitrator， 不是有法律的背景。不是律师，也不是退休的法官，一般是 commercial man。commercial man 就是有商业、有经验的商人 ，commercial man。也就是海事仲裁呢，有些是当过船务公司的经理、代理人，这些就是属于 commercial arbitrator， 有商业经验的仲裁员。在英伦呢，当事人有这个选择，提起仲裁员的条件，有些是需要商业经验，有些是需要船务公司管理的经验，但是50%都是海事律师、海商律师跟退休的海事法院的法官，很多退休法官。在加拿大呢的条件也是一样，在温哥华很多也是退休现在没有了，因为在加拿大已经取消退休年龄了。我回加拿大，我可以当法官到105岁。但是最重要的是，仲裁员呢必须要公正，这是很重要的。法院呢随时可以裁判仲裁员，假如是他的作风表现没有公正性，也可以取消他的仲裁费用跟他的律师费用。这也是国际律师协会的条款 ，International Bar Association on conflicts of interest in international arbitration， 就是 International Bar Association， 就是国际律师协会的法规。另外，仲裁员的资格 qualifications of the arbitrator， 在新加坡呢，很明显的，当事人可约定仲裁员资格，那法院也有这个权利，法院也可以命令 仲裁员有需要什么资格？需要按照当事人的协议吗？最重要的是，在新加坡的 Model Law， 仲裁员的表现作风需要公正，需要独立。那中国呢？中国仲裁法呢 ？Members of Arbitration Commission， 仲裁庭呢可以选个人，那个人呢要有公正、独立。那一个仲裁员呢需要这些条件：第一，有8年的工作经验，不是普通经验，是8年的仲裁经验。还有呢，或者是8年的律师经验。还有第三呢，8年的法官经验，就是司法经验。还有呢 ，senior academic 就是大学老师，大部分是教授 ，engaging in law research and teaching， 这是中国仲裁法的条件。仲裁员的资格在中国需要什么都是8年的工作经验，8年的律师经验，8年的大学老师经验。In the interim awards, procedural powers of the tribunal， 仲裁庭的临时裁决和程序性的权利，这是很重要的。在英伦的仲裁宪法呢，仲裁委员会有这个资格，有这个命令，他可以做这些命令。第一呢，可以有临时的裁决，可以保全一些重要点。第一呢，需要原告给担保，担保是 security for cost。security for cost 呢，我们当海事律师呢，怎样得到这2个字 security for cost 呢 ？security for cost， 海事律师在那些沿海的国家，像新加坡、英伦、香港地方，得到这些保全。保全是什么呢？保全律师费、庭费、仲裁庭费，怎样得到呢？我们可以扣留船。扣留船英文有这2个字 ，ship arrest。ship arrest， 我也跟你 arrest her， 不是 arrest it，arrest her， 船是 her， 我们要扣留 her， 要抓 her。那么怎样得到什么呢？我们得到银行的担保函，我们得到保协会。我当过保协协会的legal correspondent， 就是每个港口都有那些律师抓船，他们那个保协协会需要找律师。我当过日本保协协会、中国保协协会、挪威保协协会、伦敦4-5个保协协会的 legal correspondent， 就是他们的内部的法律顾问，要扣留船、抓船的时候呢，拿到担保。担保呢是银行的担保，担保函是一部分是银行，不是银行的担保呢，就是保协协会的担保。第二呢，很重要的就是保全什么呢？保全财产，保全证据。为什么要需要 保全财产呢？那年来，一张空子从英伦的仲裁庭拿回一个空子，就是那个仲裁裁决，没有用的。我当律师第一个最要，我当海事律师跟张律师一样，第一个条件是不需要赢了一张纸，仲裁权没有用的。最重要怎样进行？假如是被告没有财产，是浪费律师费、浪费庭费、浪费时间，这是我们当律师的责任。所以每次我在英伦是一样的，我说我可以赢的哪一张仲裁权没有用的，你让我赢，我收你的律师费，但是怎样的是没有保全财产，最主要是还有仲裁之前呢，还要保全的是什么呢？证据，证据是很重要，保全证据，保全费用，保全财产。Next one, please.
在英国1996年的仲裁法中，第38条和39条规定了仲裁庭的临时裁决以及程序性权利。第38条中说到，仲裁庭有权作出命令或者指示，但需要尊重当事人的约定。仲裁庭可以裁定申请人对仲裁费用提供担保。此外，如果财产与仲裁程序有关，仲裁庭可以依据当事人的申请进行检查、拍照、保全、保管或者扣押相关的财产，还可以从财产中提取样品进行实验并观察。仲裁庭在必要的时候会对当事人或者是证人提供的证词做出监督。第6款规定的仲裁庭可以指令任意一方当事人对其所保管或控制下的证据进行保全。第39条规定，仲裁庭可以做出临时裁决。
临时裁决是非常重要。Interim awards procedural power of the tribunal 就是仲裁庭的临时裁决和的程序性的权利。在新加坡呢的国际仲裁法，那仲裁庭呢可以命令这些，就是刚才我已经提起了，就是费用的担保，还有保全，很重要的是证据，还有财产。但是中国这一点跟新加坡不一样，这些临时裁决需要一个法院才可以给这个命令这种临时的裁决，在中国和新加坡这一点不一样。Next one， 另外，
在新加坡的国际仲裁法中规定，仲裁庭可以发出命令，例如裁定当事人提供费用担保，由银行出具担保函，以及核实证据和作出临时禁令及其他的临时裁决。此外，仲裁庭有权监督当事人、各方及证人的宣誓或声明。在中国，只有管辖权的法院才能采取临时措施。
Mediation 条件 agreement as to consent or what？ So 调解呢，也就是当事人两边都 同意，那调解的可以当初调解，他们讲的是同意调解，也可以当初裁决书，这是可以的。我记得只是在新加坡，不是在英伦，好像在加拿大联邦法院跟省法院、高级法院，你要得到调解的协议，你才可以开始在任何法院开始没有调解协议，不能够在法院解决你的法律问题。那在新加坡呢，一般呢也是鼓励调解，仲裁可以有3天的仲裁时间。那假如是那个仲裁员呢，还是仲裁委员会觉得当事人还可以用更好的方式解决他们的法律问题，他们可以利用一部分的时间去调解。在英伦呢，没有 specific provision 说这个调解人呢可以选仲裁员呢可以选调解的方式。在 LMA 就是英伦的海事仲裁的一个调解法规呢 ，provides that mediation settlement 就是调解协议可以当一个仲裁裁决，在新加坡也可以，我知道可以的，因为我有审过2个像这样的案子，在新加坡，在加拿大是确定可以的。在英伦呢 ，The London Court of International Arbitration 的法规呢，没有清清楚楚去提起什么时候可以转给调解人，还有呢，也没有说明的调解协议不可以当一个仲裁裁决。在英国我真的还不知道，但是在加拿大、在新加坡是肯定可以的。另外，mediation agreement as consent award 调解呢，根据和调解的协议做出裁决书。我刚才已经提起了，在新加坡呢，在英伦，在新加坡有一个特别的 SMA， 也有一个 arbitration mediation arbitration protocol， 就是一般仲裁、一般调解的系统。在新加坡调解仲裁中心跟新加坡国际调解中心也有一个调解仲裁的程序。在中国呢 ，CMAC 就是中国海事仲裁委员会法规，他们有这个权利，就是仲裁委员会有这个选择 ，has the option of settling dispute by mediation during the arbitration process， 在仲裁庭的时间，也就是3天也好，1个星期也好，他们随时有这个权利转给一个调解庭去解决当事人的纠纷问题。然后呢，假如是有协议呢，可以把那个调解协议当一个仲裁裁决，在中国是可以的，在新加坡也是可以的。另外，
在新加坡的国际仲裁法中没有具体条款授权仲裁员进行调解，没有根据调解协议作出裁决书的详细的规定，但是新加坡海事仲裁院有一个协议对此有规定，可以根据仲裁调解仲裁程序获得的调解协议作出仲裁裁决书。根据纽约公约的规定，这可以作为仲裁裁决强制执行。在中国海事仲裁委员会仲裁规则中，也规定了仲裁庭可以根据调解协议制作裁决书。
中国肯定是可以的，因为中国那个海事仲裁委员会的法规就是有这个条件。就是 Next one, please. 申请上诉到法院。在英伦呢，是第一 arbitral awards， 裁决是 final binding 是有约束力的，除非当事人两边原告被告还是2个3个当事人同意那个裁决，还可以上诉到法院。还有在英伦呢，还有一件就是 challenge anytime 他们可以 challenge那个裁决，但这一部分就是69条款，就是假如是仲裁院还是仲裁庭还是代表律师，他们可以上诉。假如是国家的法律分析的不正确，还是有错误，这种情况肯定可以上诉到法院。这69条款非常重要。Appeals on points of law allowed if the condition therein are satisfied。但是我可以说，申请上诉在英伦的机会是很少，很特别的机会很少。在申请上诉，最重要是在中国仲裁裁决的业区性是 arbitration award is final， 这个字就是 final，right？ 还有国家人民法院也不会说 any dispute 再审过，当事人已经经过任何 CMAX 还是仲裁庭已经得到了裁决书，法院不会接受，也不会影响任何裁决。Shall not accept the reapplication， 就是再审过同样的纠纷，当事人已经交给仲裁院，仲裁院已经出了仲裁权。Okay, next one. 申请上诉的原因，上诉假如是不成功呢，当事人还可以申请在英伦呢把仲裁权取消但是我写的清清楚楚，那些取消的原因呢是很特别，很少可以得到的机会。在英伦，在新加坡是 model law， 在 中国呢是58条款到61条款，机会呢是很少，赢的机会呢也是非常少。取消一个仲裁裁决是很难的，法院一般在英伦、新加坡，包括中国会影响。最后就是仲裁裁决，仲裁裁决就是一张纸，你没有保全当事人的财产，只是得到一张纸，除非你有库留存、有银行的担保、有保赔协会的担保，你才可以进行仲裁裁决，不然呢，只是一张纸。在英国呢，裁决少数服从多数，就是呢，假如是 award may be by the majority of arbitrators， 假如是仲裁委员会有3个仲裁员，1个反对呢，就是少数；2个同意呢，也是一个裁决。majority 在英伦呢也是一样 ，award must be in writing， 要书面 ，and signed by the arbitrator， 全部的仲裁员要签名，包括那个不同意的也要签名。Tribunal may make interim awards， Tribunal 就是仲裁庭、仲裁委员会有这个权利，他们可以命令临时的仲裁裁决。在新加坡呢，仲裁裁决 Model Law 31条款，书面全部的仲裁员要签。还有呢，还有一件事就是 reason 需要理由的吗？仲裁裁决有理由的呢，还是没有理由的 ？Right？ 一般呢，一般的是很简单的海事仲裁裁决，不需要有理由。有理由的呢，就是比较复杂的案子。So， 除非当事人同意有一个裁决，不需要有理由。在中国呢，中国不一样，24条款仲裁裁决需要有 reason for the award， 裁决一定要包括理由，什么理由？这就是在中国的需要，在中国的海事裁决法律的要求。OK，
在新加坡，示范法第31条规定，裁决以书面形式作出，并由仲裁员签名，除非当事人同意，不需要说明理由。裁决需要说明理由。在中国仲裁法第54条规定，裁决书应当写明仲裁的请求、争议事实、裁决理由、裁决结果、仲裁费用的负担和裁决日期。当事人协议不写明争议事实和裁决理由的，可以不写。裁决书由仲裁员签名，加盖仲裁委员会的印章。对裁决持不同意见的仲裁员可以签名，也可以不签名。
还有最后呢，今天我没有放 conclusion 呢，我觉得在海事海商纠纷的问题，通过仲裁 仲裁庭解决纠纷的问题是最好的方式。第一呢，不会影响到商人的感情，这是一件很方便的事情，可以省时间，可以省很多费用。仲裁裁决在仲裁庭不是公开的，跟法院不一样，可以保密的。这是我的意见。我今晚要感谢唐佳英给我的助理帮我读中文，还有帮我研究一些仲裁法律的问题。谢谢唐佳英。
Hello. I am Philip Teo, the second speaker. I will be speaking in English. I am very happy to be invited together with my good friend Peter Cole to present this evening's seminar. I'll be touching upon current issues on maritime arbitration, but some very brief comments about myself. I've been a Singapore and Malaysian lawyer for 30 years, and Peter and I share a very close history because I started my practice as a Singapore lawyer after qualifying from NUS Law School, and I started my legal career in Peter Cole's law firm. I'm currently also an arbitrator with the three main maritime arbitration centers of LMAA, SCMA, and EMAC Dubai, and other centers as well. This is in the slides. I would invite you to write to the center for a copy of the slides. From there, you will find my contact details, and I can share more materials which I refer in my slides. Next slide, please, Jeff. Shipping is international. Whether you are in Hainan, Kuala Lumpur, Port Klang, Singapore, Hong Kong, when you deal with shipping, you are actually dealing with international commerce and international law. When you buy goods from Germany, you buy an imported car from Germany, that car will be shipped to China. So you'll be dealing with a German seller. You are a Chinese buyer. The ship carrying the car could be a Korean car. So straight off, you can see that there's a lot of international elements in shipping. So are the contracts. Next slide, please. Jeff. And this is from an English case. In maritime commerce, when you deal with shipping, you're dealing with agreements and contracts. And sorry, go back to that slide, Jeff, that slide. And this is a statement by an English House of Lords judge. This is the highest court in England, where Lord Mastill, a very respected arbitrator, judge who is very established in arbitration and also maritime law, says the law and practice of shipping law have always been intertwined. There can surely be no other branch of commerce where the practical people know and need to know so much of the law, and where the professionals need to know so much of the practice. I want to illustrate by illustrating this simple document called the Bill of Lading. The Bill of Lading is a document universally employed in shipping. And the document itself, the bill of lading, has a lot of important effects in commerce. And that effects in commerce allows parties to trade. The document itself, by its name, the bill of lading, has several important functions. And the important function is that three main functions. For example, it is a contract of carriage. How is it a contract of carriage? You look at the reverse side of the bill of lading. There are terms there. Sometimes the bill of lading incorporates the charter party terms because there is a charter, and the charter party terms also come into the bill of lading where it is referred to. Second function of the bill of lading, it's receipt as to goods. Meaning, if you look at the front of the bill of lading, it says 5 crates machinery, 1 container, STC, how many boxes, television sets. So that shows the receipt as to goods. But the very important function of the bill of lading, it is also the document of title. And what do I mean by that? There are many cases where ship owners release cargo without accepting the bill of lading, the original bill of lading, because maybe the person at the port of discharge is careless. So when the goods are released, 3 days later, another party comes with the original bill of lading. The ship owner has to compensate him. I've handled many cases such as that. If you send me an email, I will give you those cases. So the persons handling documentation in a shipping company or the shipping agent would know that they cannot deliver cargo without presentation of original bill of lading. In other words, this person who is handling documentation, he is not a lawyer, but he is able to practice shipping law because the shipping law says you cannot deliver cargo except in exchange of bill of lading. Likewise, the maritime lawyer would know this is the practice and this is the law. Next slide, please. Sometimes in maritime law, the ship is detained, the crew is detained. This was the case where I was dealing with some Western crew of a ship which was detained for anchoring without permission. So when ships are detained, why are they detained? They are detained because the ship owner did not comply with the laws of the water the ship is. And this brings into play this very important role, international role of regulation of shipping. When you say you are a ship owner, say you are a Chinese ship owner, your ships are registered in China. So that ship which are registered in China are Chinese flagged ships. So the ship has an identity. And when the ship comes into Malaysia, that ship comes into Malaysian waters, the Malaysian ports. The Malaysian waters is the port state. So the ship has to obey the laws of the flag of its own country, China. Also have to obey the law of the waters the ship is in. So this is what is called the flag state and the port state control. All right. In maritime arbitration, some of these issues do crop up. Next slide, please. What are the common disputes that can arise? Ship sale and purchase. I've handled ship sale and purchase as arbitrator, as counsel as well. In one case, in the Singapore Chamber of Maritime Arbitration case, which I handled last year as counsel, the issue was whether title in the goods had been transferred, even though the bill of lading has been given to the buyer, because the full purchase price has not been paid. So issues like that arise. And sometimes the issue that arises is whether there has been a breach in the sale and purchase agreement. And I mentioned that shipping is international. When you deal with international parties, they may use standard forms. When you deal with ship sale and purchase, you might be using the Norwegian sale form, and recently the Singapore sale form has also come out. Delivery disputes. When the ship is delivered and after sailing for 6 months, the ship has problems. So that is a dispute, which shows that the seller's warranty needs to be performed. There is a claim against the seller. And in many MOAs of ship sale and purchase, there will be an arbitration clause. Likewise, charter parties will have arbitration clauses. If parties use the BIMCO standard form, like bulk time, GenCon, and other forms, supply time, there might be a charter party clause providing for arbitration in London, usually LMAA, Singapore. But parties should realize when they negotiate and confirm a charter, they can decide. They can decide Hainan International Arbitration Court. Why not? And I will explain why sometimes it does not make much of a difference. Cargo detention, cargo damage. This happens in shipping claims. Quality and seaworthiness. Also, it can be under MOA dispute. Bunker disputes. The bunker sale and purchase contract will have an arbitration clause usually. Marine insurance. Usually, this will be the marine hull insurance policy with an arbitration clause. But marine cargo policy, you do not have an arbitration clause because the cargo has the ability to transfer many chains. One party who buys the cargo can sell to another party, and that party can sell several times. So it is not practical to have an arbitration clause. Salvage, general average, the salvors, the persons providing these services will have an arbitration clause. Then you have other shipping related contracts, oil and gas industry. In fact, the Malaysian example, a lot of ships in Malaysia serve the oil and gas industry. And these are what you call OSV, offshore service vessels. Next slide. Jeff, next slide. So when you look at merchant shipping laws govern the ships of the particular country. So the merchant shipping law of Singapore, Malaysia, govern not only Malaysian registered ships, they also govern the operation of the ports. They also govern the ships which are registered in Malaysia and Singapore, but also what is the law that applies in Malaysian waters. So a Chinese ship coming into Malaysian waters, if there are requirements to be made for declaration or the qualification of the crew, this will be set up under the merchant shipping laws. But if you look at the merchant shipping law of different countries, they have a common underpinning or common origin. The common origin is that this is derived from IMO, International Maritime Organization, which Malaysia, Singapore, China is party to. And under those IMO regulations, there is uniformity of certification of crew, watch keeping, and this comes from conventions under SOLAS, Safety of Life at Sea. So these SOLAS conventions are widely recognized. SOLAS actually came about after the incident of the Titanic that sank in the 1910s. After Titanic sank with a loss of life of 1,500 people, the shipping community was shocked because the ship was seen to be the most advanced ship of its age and of superior engineering. So they had to revisit the state of shipping. And over the years, many regulations were issued under different chapters of SOLAS. And this is adopted in many countries. Ships have nationality, I already mentioned. So where the ship is registered gives its nationality. I will bring about the problem with the cruise ships in a while. Flag state is where the ship is registered. Port state is where the ship is at when it sails. Next, please. The next slide. IMO. So the merchant shipping laws actually incorporate the IMO regulations which the country has adopted or acceded or ratified. And the standards of safety, security of international shipping. One example, the World Trade terrorist incident, when the terrorists crashed into the World Trade, IMO came out with the ISPS code, which dealt with safety of shipping, safety of ports. Another regulation that applies is the pollution regulation to prevent pollution at sea. Construction of ships. There is another set of regulations also under SOLAS. For example, if you hear of this double hull, the requirement of double hull ships, that was also under SOLAS. And this year, even before the pandemic occurred, 1st January 2020, you have the IMO Sulfur 2020. IMO Sulfur 2020 requires all ships sailing internationally to have a low sulfur fuel. And disputes have a reason. I've advised parties that, sometimes when you avoid charter, you pay a certain fixed charter rate. But because of IMO 2020, the ship owner incurs more costs. Can he pass those costs to the charterer? It depends whether in the charter party agreement there is a variation capability for the ship owner to pass this cost on. Next slide, please. So when you deal with shipping, there are many categories. You have dry shipping, which is essentially matters pertaining to the contracts of carriage, construction, ship finance, port infrastructure. Wet shipping, something that happens during the voyage. For example, the ship being stranded, the ship being grounded, general average, not general, collisions, casualties, removal of wrecks. Next slide. When you deal with a maritime arbitration matter, in essence, you are dealing with a maritime dispute, a dispute between the two parties. You must look at the contract you are arguing over. All right? So if you have a dispute between a Chinese party and a Dutch party, it may be a shipment from India to China. So which is the contract of carriage are you arguing? Because if you look at charter parties, the charter party between the Chinese party and the Dutch party may cross-refer to another contract. And when you deal with a dispute between two parties, you are actually looking into issues of international law. So before you determine the dispute in arbitration, you must determine which law applies. Peter has indicated the arbitration law of China, arbitration law of Singapore, and the arbitration rules. Those are procedural rules. This is what is called the law, the procedural law, but you also look at the substantive law. So the arbitrator must look at the substantive law. The arbitrator need not be Dutch, need not be Chinese, but when he looks into the law, he may need evidence from, say, if it's Indian law, from an Indian professor. So the applicable law is something you have to determine. And sometimes the applicable law does refer to conventions. If it refers to the Convention of the Hague Rules, then you must realize that the Hague Rules is interpreted in many countries. And in those countries, you should have universal interpretation. So the arbitrator in the Hainan International Arbitration Court cannot say, I don't agree with the English court interpretation, so I will decide in another way. So there must be uniform interpretation, right? And that will bring the result in line with what is commonly understood in international trade and commerce, and make sure that the decision derived in the arbitration is a correct one. Next. The understanding of the industry and practices is very important. And I already mentioned bill of lading. So what are the shipping documents? Those are very important. So the document may call itself a bill of lading, but the document which looks like bill of lading may not be negotiable, meaning you cannot, there is no need for you to present this document to collect your cargo. In that case, the document which looks like a bill of lading will not call itself a bill of lading, it will call itself a seaway bill. Then there are other variations, contract of affreightment. When you look at shipping, some of these technical terms are very important. Laycan for charter party. What is laycan? When you charter a ship, a voyage charter, if the ship doesn't arrive on the day of appointed day, you as charterer can cancel the ship. If the ship is 1 day late, you can cancel the ship. So that's a laycan under a voyage charter. But does laycan apply when you have a contract of affreightment? It doesn't. So you have to be very clear when you use the technical terms, what they mean and in what context. So when you appoint a maritime arbitrator who is familiar with all this, even if the lawyers miss this, the maritime arbitrator can, during the preparation of the case leading to the hearing, this is what is called case management, or in arbitration terms, the procedural orders, they will direct the parties. The arbitrator will say that, look, I note that you have narrowed down these issues, but what about this issue? So the experienced maritime arbitrator, familiar with maritime law, will direct the parties so the proper issues are determined. And method of contracting, fixture notes, booking notes. A lot of times, if you are lawyers handling the case, when the client come to you, they already agreed to certain terms. And sometimes it's not in their favor, because when they contracted, they never realized, they never scrutinized the terms in the fixture in the charter party. And when you deal with documentary letters of credit, then it has its own technicalities. Meaning, if you pay under a letter of credit, the parties deal with documents, not the physical transaction. Then, when you come to other terminology, FCL cargo, LCL cargo, CYCY, then in a chartering sense, you have SHEX, Sunday holidays accepted, SHINC, Sunday holidays included. All right. Next slide, please. This year has been bad for shipping. In fact, I've written several articles, and you can easily find my articles in this shipping journal, Maritime Executive. Is available online. The first article I wrote was Shipping in a Changed World, How the Pandemic Affected Shipping. I also wrote another article on the Beirut explosion. The Beirut explosion was very bad, but I also drew two more examples. What happened in Texas, and in another case, what happened in China. But I also drew my own case which I handled in the Malaysian Admiralty Court in the case of the Ing Hua Fu, where the goods of chemicals shipped in Penang port was dangerous chemicals, but the forwarder described it as agrochemicals. Penang port was the first port. When the ship went to the second port, Port Klang. In Port Klang, what happened was, while the ship was in the course of loading second cargo, the chemicals by themselves burst into flames, caught fire, exploded, and the whole ship sank in 20 minutes. And in that case, the Malaysian Admiralty Court gave a very good 60-page judgment, accepted my submissions on the IMDG code, International Maritime Dangerous Goods Code, which was issued by the United Nations. And this code applies universally. So that decision is a very good exposition on the rules, and I've not seen such good exposition in the English courts or any other Commonwealth courts. So again, drop me an email, I will give you the decision. The other article I also wrote, yes, keep that slide, is ship management post-COVID-19. Princess Cruise. When the cruise ships had a lot of virus problems, people were sick, they call upon the ports. But the ports in Australia, other countries refused to let the cruise ships disembark the passengers. Why was that? Because these ships were registered in countries like Panama and other countries called flags of convenience. What are flags of convenience? Countries like Panama, Mongolia, Liberia, which don't even have ports, but they accept ship registration. And one of the grounds people do go there is because they are more lax. They are more easy to register. Their safety standards are not so high. So when the ships, the Ruby Princess came to Australia, the Australian government didn't allow them to disembark. Because if that ship was an Australian registered ship, no way the Australian government would refuse disembarkation. Next Next slide, please. See, a lot of problems in shipping caused by the pandemic, the effects will still continue. In fact, the effects are continuing, and this will result in more disputes, more cases going to courts, going to arbitration. And actually, the legal cases, in the most part, is not caused by the pandemic, but it's caused by the disruption caused by the pandemic. In one case I act for Tenaga National, which produces electricity in Malaysia. Tenaga National operates many plants, either joint venture in various parts of Malaysia, and a lot of these plants run by coal. So there was one case where one shipment of coal from South Africa could not be shipped because there was a lockdown in the port. The facility could not produce, could not ship, and the ship had already arrived. You know, when ships arrive, the meter starts ticking. When the ships arrive, they will give a notice of arrival, and this starts the clock ticking as far as the charges are concerned. The charges for the charterer to pay. And some of these charges, it could be as normally 5,000 US per day, but it could easily run into 100,000 US dollars a day for LNG ships. So when the ship arrives, the cargo cannot be loaded, then, you know, the charterer would have to pay how many days times 5,000 US. So you have the ship there, you have the shipper or exporter who is not shipping or not delivering. So you have a dispute between buyer and seller. But sometimes in that particular case, you have what is called a force majeure clause. But as far as the ship is concerned, that meter will start ticking. Next slide, please. And even without the pandemic, how much you pay also depends on the type of charter. If you charter a ship, a voyage charter, when your meter starts ticking depends on the type of charter. If you have a port charter, meaning when the ship arrives at the port, the meter already starts. So if you are buying cargo from India and the Indian ports are very congested and known to be congested, you are into trouble. You know, sometimes you have to wait for 2 weeks, 3 weeks, 1 month before a berth is available. And if you're the charterer, you're going to pay all these charges. But a berth charter, the meter doesn't start running until your ship has an available berth. So people involved in shipping, they would know what to choose. But from time to time, you may have a client who decides, oh, I want to, you know, import this cargo for a project, and they are not advised. They don't scrutinize properly their charter party terms, and then they're in trouble. Next. So another problem, which also occurred this year, the oil prices. A few years ago, it dropped very badly. No one expected this year to be worse. It dropped so badly that, you know, the freight charges was not worth it. So ships stopped sailing, but some people were able to, you know, buy crude oil and store on board the ships. Next. So there are certain issues which people, you know, the business people never think of, all because everything that occurred this year was unexpected. The price of crude oil dropping so badly, pandemic, of course, but IMO 2020, there's no excuse because the shipping community has been talking about this for years. They have started discussion even earlier than 3 years ago. So they should have been prepared. Next. I mentioned oil and gas industry. The oil and gas industry in Malaysia is much bigger and stronger than Singapore because we have producers, we have production platforms in Malaysia. We have all majors like Shell, Petronas. And in the good times when the price of oil was very high, there was a lot of activity. And when there's a lot of activity, you have a lot of contractors. And, you know, these contractors that service the platform that provides the specialist vessels, the crew accommodation boats, the anchor handling carts, these people who have the contracts may not own the ships. So what they do is they charter the ships from people who do. And they charter at a very high rate because they can get good profit. When the price of oil dropped, what happened is they find that, you know, they cannot sustain the price they pay to charter the ships. And worse still, a lot of these platforms, they stop production. In fact, if you sail along the Straits of Malacca near the Malaysian, on the Malaysian side, you see a lot of oil platforms idling. So when that happens, when you are cut off by Petronas because Petronas can no longer or do not need your service, but you still have another 3 years, you try to get a reason to get out of your contract. So in those cases, there'll be a lot of breach of contract. Another situation, just to give an example, when I started my practice in Singapore, actually with Peter, before that, there was a lot of production of rubber gloves. So rubber gloves was good commodity to, you know, make money. Now it's come back again. But during that time, and suddenly a lot of people went to rubber gloves. So the price of rubber gloves fell. So if you have a contract buying a glove, which was signed 6 months ago, and the price falls 30%, if you can stop the contract and buy from someone else, you save 30%. So there'll be a lot of cases, disputes, when the price of commodities, the price in any of the contracts fall. Next. This is what I mean, that the drop of oil prices have a chain effect. Next. So a lot of the shipping contracts are affected by supply chain, you know, supply and demand. So all these things, when you can no longer sustain your business, not only you lose the business, but you have to pay the person you charter the ship from, because he will not want to let go, because he himself will have no other business. So whatever is happening this year, the legal effect, the legal disputes are just starting. The disputes are starting, so it will take a while to clear. Next. And shipping is part of the supply chain. And when he, okay, I think Peter had a very good comment at the beginning of his talk. And I want to add on. In a lot of arbitration centers, One of the reasons why they survive, or rather thrive, is they are able to show people who make use of the center that they have quality results, quality arbitration. So the results of cases that go to the center are decided properly in line with international accepted understanding of the laws. So these results are important. So to grow a center, the quality must be there in the beginning. And how is quality grown? One of the ways is, of course, by having training, talks. And, you need good supporters like Professor Peter who will help you grow the center. I'm available as a potential arbitrator for your center as well. But in a great sense, I can see that, the international community, when it comes to specialist areas, there is a lot of uniformity and a lot of source of information. You can easily get it from the internet. So there is no room to say that we are new, we want to decide differently. If we are new, but we're also part of the international community of maritime law, maritime practitioners, and we must ensure whatever decisions we make are in line. Next. Actually, one of the most common types of arbitration is demurrage. I mentioned already. And one of the problems that can arise during this period is one of the parties do not properly take care of their own position. What do I mean by that? I'm not talking about China. I'm talking about other countries where the lockdown is still having problem. Maybe I give an example of India. So you have a European ship owner, Indian charterer, but because of the lockdown, the Indian party, maybe he has too many things to worry about. So when the ship arrives, usually the recording of the timing, is done by two parties. So the Indian party will think, look, I've got too many problems. The contractors are not available, so I cannot record the time. But in the arbitration, the ship owner, of course, he needs a shipping agent, and he has recorded time in detail. So in a dispute, you have one party with a good time recording, the other party with sketchy or no time recording. So how do you dispute the ship owner's time recording? So if the case comes before a maritime arbitrator, there is no other way but to accept, or rather, it is more difficult for one party to challenge the other party's statement of facts, time recording. So problems like this can arise because of demurrage, claims during the pandemic. Another problem during this period is pandemic effect, or rather, the crew are infected. When the crew are infected, when the ship arrives, the health officers of the port will not give a health clearance. This means the ship will not be given what is called free pratik. And this stops the time from running because the ship is not ready. When the ship arrives, it must be ready to load. It must get free pratik. So again, these are peculiar problems during the pandemic. And, when people talk about force majeure, right? It all boils down to what is in your own contract, how tightly drawn. Some charter party contracts have very wide, already detailed clauses to include even pandemic. So those are very tight. But you also hear that certain countries, again, I refer to India, where the states have issued force majeure orders. This have no effect. Because how is the municipal or state government having any role in a contract between a charterer and a ship owner? So those are peculiar issues. All right. Next. Peter also mentioned whether one arbitrator or two arbitrators or three arbitrators. I've handled many cases where I was part of a panel. And being part of the panel, in most of the cases, I'm appointed either the first or second arbitrator. And in the charter party contract or the contract under which I'm appointed provides for a panel of three. Usually, in order to proceed faster, I suggest to my co-arbitrator, and we suggest to the parties, look, the contract provides for three arbitrators. Would you want to proceed with just two of us? If you do, it'll be faster. There'll be some savings. So, but on this condition, in the event we do not agree or there's a deadlock between me and the co-arbitrator, at that point of time, we bring in the third arbitrator. Usually the parties agree. And when they agree, we ask them to amend the arbitration clause. In another case where an English lawyer was involved, the English lawyer said, we agree, but we don't think you need to amend. Why don't you, put it down in a procedural order? And that's what we did. And this was a case which we recently concluded. Next. Next slide. So, then there are certain other issues also. The pandemic effect, whether if a port is so affected that it's closed down, there's no working, or the port will insist that all ships coming into port will have to be quarantined, whether that is a safe port. So as a charterer, when you tell the ship owner to go to a particular port, you warrant that that port is safe. So if the port has pandemic issues, whether there's a safe port warranty, port shutdown, supply chain disruption, then you have slow working of ports, meaning because of the pandemic, the stevedores of the port are not fully there, or there's a total shutdown in the factory, or the warehouses have no cargo. Then at delivery, the cargo is not collected. So all those issues, port congestion. In Malaysia, in many cases, there's a lot of port congestion because people don't collect their cargo. So these are problems that can arise in shipping during this period. Next. I won't go into this because I already mentioned port and berth charter. Next. This is an illustration of what is called, uniformity. When you buy cargo from Europe, Malaysia, you'll find that, the cargo which is insured, they are usually insured under English forms. So when you use English forms like institute cargo clauses, you'll find that there is a choice of English law. It says English law and practice. So when a Chinese party imports cargo from Japan, if it's insured by an international broker or arranged by a broker, then you'll find that English law clauses apply. And when the Chinese exports to Malaysia using ICCA. So that insurance will be subject to English law. And if you check a lot of ships, you'll find that, if you are insured with Chinese insurers, Ping An, PICC, SIPIC, you'll find that, the cargo clauses are the same. Why? Because Chinese insurers also reinsure internationally. So the international reinsurers will only be familiar with the common clauses. Next. Peter mentioned some interim relief. I want to mention this particular relief called emergency arbitrator. What is emergency arbitrator? Peter mentioned parties sometimes can get relief from the court by taking orders of discovery, taking orders of interrogatories. But certain arbitration centers, perhaps Hainan International Arbitration Court, have provision to appoint an emergency arbitrator. Who is the emergency arbitrator? He is the person where the center, because the rules of the center provide for appointment of this person before the main arbitrators are appointed. So one party wants an order that the other party do not dispose of anything similar to injunction, then the emergency arbitrator is the one who makes such an order. His role is temporary, interim. So he doesn't decide on the main dispute. He makes interim orders. So countries like Malaysia, Singapore, UK, all recognize emergency arbitrator. Next. The other aspects you have to bear in mind, Peter also mentioned ship arrest. I regularly handle ship arrest matters, whether to arrest or defend arrest. And while a case is going on for arbitration, in many countries, UK, Malaysia, you can arrest the vessel, not for court proceeding, but for the ongoing arbitration. So the ship arrest could be in aid for your arbitration. Okay, arbitration is international, and you will find that, if your client is a Chinese company, if the other party is a non-Chinese party, arbitration is the only way for them to resolve a dispute. Because for example, if there is a dispute between a Malaysian party and a Chinese party in the Malaysian court, if the Malaysian party wins a good result in the Malaysian court, the Chinese courts do not recognize Malaysian judgments. But if both parties have an arbitration award, there is this New York Convention regime of recognition and enforcement of arbitration awards. That award will be recognized and registrable in China. Similarly, US, Indonesia, amongst many other countries. So contract between Malaysian party, Singapore party with American party, you have to have an arbitration clause. That is a very important selling point for you to tell your client, for those people who do not know. No point fighting in a court in China with a foreign party, even if it doesn't appear, because you cannot enforce out of China. But if there's an arbitration award, even if the other party doesn't appear, if you go through the processes, I've done a case, the Singapore case I told you, the UAE company didn't appear, but we argued the case before the 3 arbitrators, and now my client is proceeding with enforcement in UAE. Then the other issue you have to decide is choice of law, which law to choose. And certainly, when the law is chosen, that law has to be applied. And in the arbitration in Hainan International Court, so experts can be called to give what is the effect of the law in that particular area. I've handled cases where the law is Indonesian law in Singapore, arbitration, and we use Singapore law professors. Next channel, please. Next slide. Next slide. Okay, so these are my panels, my arbitration panels. Malaysia, AIAC, London Court of International Arbitration. LMAA is the most important maritime arbitration center. ICC is the Paris one. Singapore is SCMA. Okay, if you appoint an arbitrator, even if I'm not an arbitrator in that particular center, I can still be appointed. So I've chosen to be members of this center, and I understand my application to be arbitrator in the Hainan International Arbitration Court is pending. Hopefully it will be approved. The other center I'm also a member of is KCABA Korea. Next slide, please. These are the books I've written. These books which I wrote are on Malaysian law, but Malaysian law has its underpinning or basis under English law. So a lot of the books I wrote also have English cases because Malaysia, Singapore, we were once under British rule. So our laws are British based. In fact, the ship arrest regime, we directly apply the UK Supreme Court Act. I also mentioned the Marine Insurance Act. That one we use English law. So you can see that a lot of the areas relevant to these maritime disputes, I not only practice as a lawyer, but I also wrote the textbooks which are used by judges, arbitrators, and other lawyers. The next slide is my contact detail. Next, Jeff. I hope I have a WeChat number, but it's not here. But you can send me your email. I will be more than happy to get to know you and keep in touch with you. And if you have a LinkedIn account, I have a very strong network on LinkedIn, and you can see that I regularly share information there. So with this, I end my presentation, and I look forward, together with Peter, to answering your questions. Thank you, Jeff.
Yeah, to of the professor. Now the online lecture is end. I see on the Q&A session they have some of questions, but because of the time, I would like to ask two of the professor. You would like to answer the question by email, or we have an online question answering?
We can have.
Yeah, we can take a few questions, Peter. I agree. Then, if the rest, maybe Jeff, you can forward to us as well. But we can take a few questions.
Yeah,
Jeff, I leave it to you to choose the questions. Otherwise, that will be easier. Maybe the questions you have most relevance to everybody.
I slept one of the question, and they say, would Australia for the case you shared just now, would Australian refusal for this implication for COVID reason be as human right and safety?
Well, yeah. You mean refusal to allow the ship to disembark the crew?
Yeah, if you say you say if the ship is registered under the name of the Australia, however, of the COVID and the human rights, the 2-point battle, which one we win? Something like that. Is the
okay? Just to say on that, you see, the ship which calls in Australia is registered in Panama. All right.
Yeah.
So the Australian government is concentrating on the safety of its own people. They dare not have crew with so many infections to come on board or come off board into the country. So, you know, when you have issues of human rights, again, you also have issues of own security of the country. But the problem, not just one ship, but many of the cruise ships, shows that the practice of registering ships in countries like Panama, Mongolia, have this bad effect. All right? So that's all I can say. But if you want to find out more, you can look for my article.
Okay. So I have one more question to Peter.
Ask the participants to ask me rather than read out the questions.
Yeah, I see the question they talk about, is it the Singapore arbitration law is the 100% the same of the model law?
I did mention that Singapore international arbitration has, can you hear me?
Yes, I can.
Can you hear me?
Yes, yes.
Okay, has very strong influence of the model law.
Yes.
I mentioned this in 第2章还是第3章，我都忘记了。
Yeah, the question is it the 100% the same or no?
100% the same. What did I mention in the slide is the Singapore has 2 arbitrations 宪法，一个是国际的，一个是国内的。那个国际的是按照联合国的 model law。好吗
？Okay， 好的，好的。So let's call it for a day. We end here, and because some of the question I will email to both of you, and if you can answer by email, I will publish to the participants. Okay?
他们可以用中文没问题。
就是如果大家还有其他的问题的话，可以通过提问的方式在这个 Zoom 里面提问，然后我们会选择一些有代表性的给让老师回答，然后以邮件的方式或者以其他的方式回答大家，或者以邮件回复的方式单独回答给大家，好吗？今天的时间关系，我们在这里就结束了。再次感谢2位老师的精彩的分享。Thank you, Peter. Thank you, Philip, and thank you so much for your wonderful lecture tonight. Have a nice weekend.